Hello, everybody, and good afternoon, and thank you for joining Project Venus Divorce Resource. You can't take it with you, the effect of divorce and death on your assets. I'm Nicole Young. I'm the marketing coordinator for Private Vista, and I'll be your host today. Before we get started, I just want to share a little bit about our firm, Private Vista. We're a financial planning and wealth management firm in the Chicagoland area. We manage approximately $1.7 billion of assets for our clients. And we have offices in both downtown and Oak Brook. We specialize in working with women in transition, business executives, business owners, retirees, families, and qualified plans. Now I have just a couple housekeeping items to ensure that you're able to have the best experience on this webinar. You'll notice that you're muted for the duration of the presentation, and that's just to ensure that everyone can hear our panelists and that there's no cross audio. If you run into any technical issues, though, feel free to reach out to me, Nicole Young, by using the chat box function at the bottom of your screen. Any chats that are sent will be completely confidential and will only be seen by me for today's session. Lastly, if you'd like to submit a question during the presentation, please feel free to email me at pvnews@myprivatevista.com, and I'll happily get back to you, or we'll get your question to the appropriate panelist. So that's it for housekeeping, and I'd now like to turn things over to Nicole Romito and Mary Beth McLean.
Hi, good afternoon, everyone. Mary Beth McLean and I co-founded Project Venus, where women in transition are connected, supported, and inspired to enrich their lives through financial planning, education, and partnership. Both of us are passionate about providing women access to the information and resources they need so that they can move from a place of feeling overwhelmed and anxious to one where they can move forward with confidence and clarity. Since we are holding our events virtually, we have opened these sessions to both men and women who are thinking about or going through a divorce. And before we start answering the questions around our topic today, each panelist will take a few moments so that you can get to know us and our backgrounds and our specialty and wisdom that we'll be sharing today. I'll go ahead and start. As you know, I'm Nicole Romito. I am a partner and lead advisor at Private Vista, based out of our Loop office. I have spent my whole career in the financial services industry and truly get gratification, and kind of really what gets me jazzed and out of bed every morning is helping people make educated and informed decisions around anything that touches them financially. And I particularly enjoy helping women as they go through a transition, whether it's through becoming a widow or they're going through a divorce. Really walking side by side to be their partner and sounding board as they start their next chapter. Mary Beth, do you want to go ahead and give a little bit background on yourself?
Sure. Great, Nicole. Thank you. Welcome, everybody. My name is Mary Beth McLean, and I am also a lead advisor and partner at Private Vista. I am primarily located in our Oak Brook offices. And like Nicole, too, I have spent my entire career in the financial services industry. I'm as committed as Nicole is as well to being able to help women in particular figure out what their situation is, how they can get to that next chapter and making it a great chapter, and so that we can relieve their fears and achieve their dreams. So without further ado, I would also like to say that we are also both CFPs, which is Certified Financial Planners. Nicole also has the distinction of being a Certified Financial Divorce Analyst, and I have my MBA. So again, we feel that it's really, we have the credentials, but we also have the passion to make sure that we help. So thank you for joining. Eric, I'm going to toss it to you because where I see it, Beth, Eric's next. Sorry about that.
Okay, am I going now?
Please.
Okay. Yeah, well, my name's Eric Weiland, and I'd like to thank, Nicole and Mary Beth for asking me to speak today. I'm really excited to be with you guys and hopefully answer some questions. So I'm a lawyer with 25 years of experience, mostly in trust and estates, so estate planning and kind of estate and trust administration. I got a bachelor's degree in finance. I did go to Michigan State University. I went to actually Detroit College of Law, which is now Michigan State College of Law, for my law degree. And I also spent a year at the New York University Law School getting a master's degree in tax law. So in one way or another, I've always been involved in areas that seem to involve some kind of tax specialty. So trust and estates sort of has been there. I would say I used to have percentages for my practice when trust and estates and corporate and tax and whatnot. I have started to think about this the other day. I'm like, when was the last time I took a non-trust and estates case? It's been a while. Seems like that's been what's on everybody's mind. Most of my clients, unfortunately, have I've lost a few clients to COVID, so we're living in this pandemic, and I think people are paying a bit more attention to their estate plans and what's going on, and in particular in light of certainly our current circumstances. So thank you again to Mary Beth and Nicole for asking me to be with you today.
Welcome, everyone. I'm Beth McCormick. I'm a family law partner and owner at Bierman LLP. We have about 45 lawyers only doing divorce and family law matters, which involve parents who've had children in common without having been married. So I know enough to know what I don't know, and estates and trust is one area that I always stay away from. Inevitably, in a divorce matter, people want to know more about estate planning, and so I bring in estate planning experts, sometimes pretty early on in a divorce proceeding, and I always bring on financial advisors, and Nicole and Mary Beth are a go-to. We consider ourselves a bit of a power team if somebody has the luxury of having all of us. So I practice between my Bannockburn office. No one knows where Bannockburn is. It's up north and downtown. So thanks again for having me.
We're glad to have you
Thank
both
you.
here.
Oh. Thank you all for giving us a little information about yourselves. So now we're just going to start answering some questions. And we're going to start off with you, Beth, if you don't mind. And our question is our estate plan valid while we are in the midst of divorce? Can it be changed by just one of us? And Eric, Mary Beth, and Nicole, feel free to jump in if you have anything to add to this question.
Yeah, I'm scratching my head because I know enough to know what I don't know, so I'm going to be punting to Eric. So
All right. So we're okay. So this question.
I'll take it for just the divorce piece, and then I'm going to punt to you. Sorry, real quickly.
Okay.
So the main objective in a divorce proceeding, a good lawyer will tell you to maintain the status quo always. From the minute you come in, you should not be doing anything unilaterally. As far as what can be done, I'll let Eric talk about, but we always advise people never to make changes to their estate plan in the midst of a divorce proceeding, unless, of course, we have had instances where death is imminent. And then we usually try to work together to figure out what's logical for the children or the whomever is the recipient. So the main answer is you cannot and should not modify your estate plan from the divorce standpoint. But Eric, I'll punt to you as to whether you can do it.
Yeah. Okay. Thanks, Beth. Really, I defer to the divorce lawyers a lot of times. Here we are, Beth, back and forth.
Yeah.
Because I try to, if I'm meeting with a client, usually it's an individual if they're in the midst of a divorce, and they're asking me a lot of questions about doing this. And, probably somewhere in the conversation, I'm going to realize that, if they're making changes that are, kind of going to arouse concerns from their, partner they're divorcing from, it may not look so good that you're kind of doing things potentially behind it, and then the whole process of getting divorced becomes less trusted. So, but to say, if you want to change things in your estate plan, I mean, it's not that you legally can't. It's just a lot of times whether you should. So I guess the legal answer is, sure, you can change anything that you have the power to change. The question sometimes I think isn't so much whether you can, it's whether you should. I tend to, when I get those calls on the phone and people call me up, I'm getting divorced, what should I do? I say, well, why don't you get divorced first and then we'll talk a lot of times.
So it sounds like we're giving the same advice. I would just go on to say, though, that I guess I'll add a question to you, Eric. So from the divorce standpoint, let's say one of them does do it. It's my understanding that even if the estate plan is modified to name others, there is still, as a surviving spouse, until the divorce is final, they would be deemed the surviving spouse. Yes.
That's correct. You know, there's I will say this much. I think there are lots of estate planning forms out there. And I want to say, you know, not the firm I work with currently doesn't say this, but I've seen forms where it's like, if you're in the midst of a divorce, the forms might say, if I'm in the middle of getting divorced, then my trustee should treat my spouse as predeceasing me. I think I've seen some of that.
I've seen that too, yeah.
And I would probably not endorse putting that in any client's estate plan, although I have seen it. And I'm sure there's a lot of estate planning lawyers who've sat around rooms debating whether to include this language. And they probably didn't consult with Beth or the other, you know, matrimonial attorneys out there, because
Right.
it's sort of fraught with problem, because I have made and I will say this much to those listening in, I have made rather sweeping changes to people's estate plans in the midst of divorce. And because they wanted me to, they were very concerned about it. They didn't want me talking to their divorce lawyer, and they wanted to do this, and they were directing me, and they didn't care sometimes about how the consequences played out. They wanted it in that way. So, you know, it's just really, I think, evaluating circumstances. Does this make sense? You know, why are you doing it? Asking those questions.
And maybe beg for forgiveness rather than ask for permission.
Right.
I would also reiterate, though, Eric, I feel like often there is the question of power of attorney, both for healthcare, and I feel like that's something we do talk about at the very beginning of a divorce case, because heaven forbid, especially in light of COVID, you know, that the spouse that they're divorcing has power over whether to continue with life support, et cetera. So maybe I'll punt that to you as well.
You know, I guess if there's any area you might want to look at, I suppose it's like power of attorney for property or a power of attorney for healthcare. Property maybe not as critical, but obviously almost, if you come in as a married couple to an estate planner's office, you're likely going to end up with reciprocal documents, meaning each spouse is going to be the agent for the other under a power of attorney for property and healthcare. It's very rare that I sit with a couple and one spouse says, you know, I don't really want you to be my property, because otherwise they sort of walk out of my office and have a lot more things to talk about. But inevitably, you know, those are things that I would say, if you're interested in changing those are probably, you know, things that I would be fine in making the change. And maybe your divorce lawyer has recommended that too, you know.
Yeah.
So if you've got your, you know, divorce lawyer and your estate planning attorney kind of in agreement, it makes a lot of sense, I think, to do it that way. But, you know, even that you can wait till after you're divorced, because, you know, the thing is, it's a process of getting divorced. And, you know, sometimes I think, you know, there may be a spouse in there that's still thinking, well, we may reverse course and not have this conclude. That may happen, may not. I don't have any experience with that, but, you know, I guess looking at it outwardly, you know, I would kind of say, if you're going to make changes, probably best to do it after you're divorced.
I would just also, Nicole, I'm sorry, I'll go on to say a little bit about life insurance, because I feel like we are faced with that question a lot. And I think it's a misconception that life insurance, well, I'll let you speak to how life insurance and estate planning are interrelated. But from the divorce standpoint, again, we strongly encourage people to maintain the status quo. Do not change your beneficiaries on your life insurance during a divorce proceeding, maybe for obvious reasons, but I'll say once you have submitted yourself to a court, the court has what's called jurisdiction over you and can order you to do things or not do things. And if you have filed for divorce, the court does have jurisdiction over you, or if you've responded to a divorce. So you have obligations under that, often involving the spouse and or children. And often child support is, or both of those are protected by a life insurance policy. And we do math often to determine whether the death benefit is sufficient to cover those obligations. So I thought I would just throw that in there because I feel like that's a common question that my divorcing clients have.
Yeah, I would say that, if you decide to, I can sort of see this coming up, you're in the midst of divorce, you've got a rather sizable insurance policy with, multi-million-dollar death benefits, right? And you decide, boy, I'm not letting, my spouse get any of this. I'm going to go change it. And I'm going to name, these, my two kids. And all of a sudden the person passes away and the insurance company is like,
Right.
Gets a notification from a divorce lawyer representing the spouse. Hey, this was done during the pendency of my divorce. The insurance company may throw their hands up in the air and now you're in litigation, potentially with the insurance company, overdoing something. And you're creating really more legal work for the attorneys to unwind, and in reality, if that did occur, maybe the ongoing negotiations for the settlement of that divorce, could identify what to do with regard to those proceeds too.
I think too, life insurance is certainly something to be talked about. Mary Beth, and I think actually all of us on this panel have seen it, where this definitely you want to have the team approach, because not only do you want to understand what, as Beth highlighted, the legal perspective from what's the court's jurisdiction and how is that impacting either positively or negatively the conversations for the divorce proceeding, but then also too, for future estate planning. I know I'll talk to where we've seen a lot of times people will have life insurance as part of the settlement agreement because it's going to secure or act as collateral for maintenance, which was formerly known as alimony, and or child support. So if the payor dies before they have fulfilled their obligation as agreed upon, that the payee or the person receiving those payments is not losing out money that they were awarded, and or having to then be filing with the estate, right, to go after their legal claim. One common thing Mary Beth and I often see is that they will name minor children as the beneficiaries if they don't want to name the ex-spouse. And that too, and Eric, I'm sure you've seen that can come with a whole host of complications as well. So one of the things we recommend is by having the appropriate professionals on the team involved at the right times, while yes, everyone is getting paid for their time, more often than not, you're going to actually save money and certainly save anguish for the people who, they don't have to hire attorneys and then go through litigation or the courts to get what is rightfully theirs. Mary Beth, do you want to maybe talk a little bit about like how ILITs fit into the conversation as well?
Sure. A lot of times, and again, I'll punt, feel free, Eric and Beth, to jump in, but if you do estate planning, often you buy something called, it's a life insurance that goes into an irrevocable life insurance trust. And then those proceeds from the life insurance, it might be a second to die policy. It could be that you took one on either of the two spouses, but they're used to kind of alleviate or mitigate some of the estate taxes that your beneficiaries might incur as they liquidate the estate. So that was the primary reason. And it was really very critical, very, very popular when the federal exemption was really, really low. What we've seen a lot is that if they did that, particularly if it's a couple that's been in a long-term marriage, and I guess Beth, I would defer to you, but that's usually what we say, longer than 20 years.
Yeah.
We see a lot of those, and what happens to that in the estate planning process as you unwind it in the course of the divorce. So Eric, I'm going to punt because I do know that there's some recent statutes that kind of help one or the other party take over that if they're willing to do that. And it can be broken, but I'm going to defer to you on the legal aspects of that.
Okay, well, I would sort of start with the question, if there is an islet in there, generally it's going to hold a pretty large insurance policy. And likely the planning strategy, as Mary Beth kind of explained, was to create, some liquidity for estate taxes. And of course, with the estate tax exemption going up dramatically, maybe some of this planning isn't necessarily as needed as it once was. But lawyers like me tend not to tell clients to get rid of those insurance trusts or to keep those policies in force, because you never know what may change with the state taxes. True. So, but I would say that if they've done this type of planning and they are getting divorced, I mean, this is something that the divorce lawyer needs to know, that the matrimonial attorney needs to understand this. Maybe I've got to explain some of these things to them, because they may need to negotiate what is going to happen with that insurance trust post-divorce, and got to understand, what the spouse's rights are under that trust, and understand more about the insurance and what it's there, so that maybe this gets formulated into the plan for how they're, going to settle their property. Certainly, Mary Beth's right. There's lots of good statutes out there, and a lot of recent changes with our Illinois Trust Code that can allow us to maybe unwind or change some of these things to fit more in light with the fact that the spouse who's a beneficiary under the trust is no longer going to be, or, I suppose they can still be even if they're not a spouse. But just understanding, okay, this is something we need to address as we're finalizing a divorce.
Right.
I think the other thing that Mary Beth and I just wanted to quickly highlight, because we could do probably a webinar alone just on insurance and divorce and estate planning, is again, from the financial aspect, because that's the experience we bring, is when you are looking at life insurance policies, whether they're in some type of trust that were for estate planning, or they were, to replace income in the event one of the breadwinners died prematurely, is if you have any type of permanent insurance, which has a savings account or cash value component, as part of the settlement agreement, that's certainly going to be listed as an asset on the balance sheet. But just making sure that if you don't need the insurance anymore, or it's going to be awarded to you and you're working with your financial planner and that's not the best avenue going forward, you want to make sure that you're understanding what type of tax consequences, and if there's any what's called a surrender charge or penalty, if you decide you don't want to continue with that policy going forward. So again, we could spend a whole hour just talking about that, but we just wanted to kind of plant that seed that, again, by having the full team, you can make sure that you're looking at the asset and all the kind of pros and cons that come along with it.
And there could be capital gains too. You're exactly right. There could be surrender charges, but there could be potential capital gains that if you're going to cash in a permanent. And I would say too, sometimes the synonym for permanent life insurance is also whole life. So for the people that are joining us today, if you're not sure what kind of insurance policy you have, it might be called whole life or term. And those are two very distinct things, but it goes back to working with all of the professionals as a team. You really get, I think, a really good brain source there, because you're going to get different perspectives and working together for your best settlement.
Perfect.
Right.
Nicole, do you want to tee up our next question, please?
Yeah, we're going to move on to a question about post-nuptial agreements for Beth. Actually, if you want to start us off, the question is going to be, what is a post-nuptial agreement, and would someone want that instead of a divorce?
So a post-nuptial agreement is pretty much what it sounds like, an agreement that's done after the marriage, and often done instead of a divorce. Some couples do it for emotional reasons. What we often see is maybe a betrayal has occurred, and somebody wants to try to repair the marriage. They're in marriage counseling. They've discussed all the emotions of it, but they want to kind of lock themselves into something prior to really considering divorce. So there is the legal separation, which is a real option, but I don't consider it a real option because in my 30 years of practicing divorce law, I've done one, and that was done mostly for health insurance reasons. And it's my understanding that that's not even a real option anymore. So postnuptial agreements have pretty much replaced legal separations as an option for couples who want to work on repairing the marriage. Some people stay living together and go on with life, and that postnuptial agreement will set forth all the terms of how the expenses of the marriage and how assets will be accumulated. All of that is literally a roadmap for the court should the parties divorce. And for estate planning purposes, Eric, again, I'll punt to you as to how often you see them actually playing out in a death situation.
I guess I've not encountered a post-nuptial agreement. I have done an amendment after people were married to a prenuptial agreement. Maybe that counts in some way. I really have not done a lot of this because I guess I guess from an estate planning, but I'm sure there's, lots of other reasons why couples may want to consider a postnuptial agreement. From an estate planning perspective, I think you're trying to elicit one spouse to sort of waive their rights that they can, elect against your estate plan. And that may require probably some consideration for that, because you're really waiving your rights to contest. I have had, a few clients come in over the years who were married and were like, I'm not telling my spouse that I'm here meeting with you because I want to do my estate plan. And I go, well, we can leave everything to these people and leave your spouse out of it. But guess what? They can elect against all this and take it anyway. And then they kind of realize their plan to, sort of disinherit their spouse has been, thwarted anyway. But I guess that's when you start talking about a postnuptial agreement. And I guess that's, more in line. I've just not prepared one of these. I guess I remember one client, I talked to him and he came back 3 years later and told me he was divorced. I said, I guess that's how that works.
Yeah.
But but I, that's why I encourage I've done a fair number of prenuptial agreements because the concept of it is you're really just trying to say, I want to leave my property to my kids. You leave it to your kids. We'll live together. We'll have a great time. But this is how I want my estate to go.
Yeah, if there were children in advance, right? But I am often asked, how often are prenups and or postnups upheld by the court? And like many things in the law, there's a little bit of a pendulum swing. And right now, the state of the law in Illinois is such that most prenups and postnups are upheld. So it's very important that you have an expert who drafts them. And again, I know enough to know what I don't know. So I always bring in an estate planning lawyer to negotiate the death terms in a prenup or a postnup. And for obvious reasons, and I'm guessing Eric does the same. When it's a prenup and there's lots of love and hope involved, the conversations are a little bit easier, right? When they're a postnup, it can be as brutal and sometimes more brutal than an actual divorce negotiation. Because again, with experts, you're going to do it right and you're going to dot every I and cross every T and all the what ifs. And you need to have an attorney who knows what those what ifs are. I call it periscope thinking. Nicole knows that. It's my job to think for you about what you can't see around the corner and over there. So it's got to be a very thoughtful process. And if so, again, I think more often than not, it's going to be upheld. It's a good tool to use if you want to try to minimize the expense of a divorce.
I guess my experience, if you want, do I need to speak for, I was just going to add that, I guess in my situation, I have at times counsel with other marital, attorneys about, those situations. But I guess it hasn't been the practice because I think a lot of times that they already know this thing's expensive to do to begin with. So sometimes I think the cost sometimes to do more of that. And I, and I'm not trying to really, I'm just dealing with, I want to be able to name who my powers of attorney are. I want to be able to leave my property to my kids and you leave yours to that. And usually I leave it at that. I suppose if it really gets more complicated than that, I would probably refer it to someone like Beth, because I think, they're really dealing more with marital issues. And I'm trying to really focus on just the estate planning elements of this.
Well, and I also think it's important to remember sometimes when you have spouses that are now separating via divorce, there's usually one spouse, if they're not very sophisticated, they don't understand the money, and they may have signed an estate planning document that they don't really understand what they signed. So again, that goes back to understanding that Nicole and I and Beth and Eric believe strongly that you need all of the brain trust there, so that you can really understand what your current situation is, what you have that you have to separate. And Nicole and I say, don't use the F word, and we shouldn't use that one, but we also shouldn't use the word fair, because it's going to, you want to get to an equitable distribution, not one that's fair. And we hear that all the time from clients, but the first step is to really understand exactly where you are currently, so that you can have Beth as your advocate on the legal front, and then, folks like Nicole and myself for the financial fronts. And, again, Eric is also very involved in these things too, because if you have an estate plan, it's going to change, and you need to, again, know where you're coming so you know where you want to get to.
I use the word acceptable in place of fair. And seriously, in divorce negotiations, it's pretty powerful to watch people with that little reframe using the word acceptable, because equitable and fair, those are words that we all define very differently, and equitable is a term of art under the law. But rather than go into that, what's acceptable to you? So it's a good reframe. I didn't make it up. I learned it in training.
No, that's great though. I mean, I think that that's really sound advice, because as we know, sometimes, because it's also an emotional process as well as a legal and a financial process, there have been studies that you just don't make your decision-making capabilities are clouded by your emotions. So sometimes you might not really be making the best decision because you're letting your emotions kind of lead the process instead of your rational process. So.
Okay, I think we're going to move on to another question that I'm going to tee up for you, Eric. The question is, I am now officially divorced, but I do not want to spend a lot of money on attorneys and new estate plan documents. What aspects of my estate plan should I prioritize in making changes to my estate plan?
Well, I would say this. I just had a new client I met with last week who just got divorced this year. So these kind of conversations are pretty fresh with me. This gentleman didn't have any estate plan, so I'm kind of starting fresh. But if you've done estate planning and you are divorced, if you've named your spouse to be your executor under a will, well, there's statutory law out there that's going to presume because you're divorced, your spouse has predeceased. But what if you want your former spouse to still be your executor? I think that might be a reason to want to redo your estate plan, to make that change, maybe redo the will. Because if something happened, let's say there's a power of attorney out there. This is probably a very likely scenario. You've done a power of attorney. You were married at the time. The agent under the power is your spouse. You're now divorced from that spouse. The law would probably presume you don't want that spouse to be your agent, so they'll go down to the next agent on the list. But what if you want that former spouse to be that agent? I guess I've had some unique experiences with clients who are divorced, but still kind of maintain, fairly good relations with their ex-spouse, because a lot of times they'll have kids together. I guess, you know, in from Beth's area, sometimes maybe it's probably not so surprising, but, you know, given that everything that's gone on, and a lot of times I've heard, you know, people come and say, when you should come and get your estate plan. I said, well, you probably spent a lot of money just getting divorced, you know, and let's kind of attack this. So I would look for those issues within your estate plan to kind of change, and not necessarily try to overhaul the whole thing. And that obviously will save you some money too, you know, less work involved. But go back to the lawyer you worked with previously, because I think, you know, that they may be know your situation, very easy to get involved. A lot of times I find if I'm working with new clients, I need to spend some time just getting to know them, their situation. And obviously I'm unfamiliar, but if you have worked with an attorney in the past, there's nothing wrong with going back to that attorney and you know, working with them to update your estate plan.
I'll just piggyback a little bit. The collaborative law world that I live in, there are actually estate planning lawyers who are trained in collaborative law. You don't need that expertise, but or the collaborative expertise is not as necessary as the ability to kind of help a couple navigate post-divorce what they're doing together. Because by its nature, collaborative, a typical goal for a divorcing couple is to have some after marriage relationship, as you point out, Eric, often for the children, and they want to align their estate plans. So we negotiate estate plans within the divorce and time it all so that it is done according to what they want. But of course, there's nothing post-divorce that says that couldn't later be modified. So no matter all the words in the world in a document, you cannot keep a person to that. So that's more of a goodwill gesture.
Yeah, in my estate planning process and working with people who've been divorced, I you know, if the conversation kind of develops, I might ask to see what their divorce decree says. Maybe they have made provisions regarding and they just forgot about this. So, you know, that's good to be aware of those things. You know, sometimes as an estate planner, I'm kind of sitting there with the clients in a meeting and thinking they know everything about their assets, and they may not. They may not have remembered doing this. This is just a real quick case, but I'm trying to represent an administrator in an estate right now. And the decedent was divorced, remarried, and the first spouse is still alive. And there's an IRA that got set up like 30 years ago when he was married. And you know, the beneficiary may be still the first spouse. You know, what do we do here? You know, and the IRA administrator is just like, hasn't really gotten back to my client because they know it's a problem. So we've had to use a little more forceful action to get this information. But, you know, you know, and one of my comments is like, I think we still have access to the first spouse, and like, let's go find out, maybe you were supposed to keep that asset in the divorce. Let's look at that, you know. So
anecdotes are sometimes helpful for people. And you reminded me of the case, was not mine. It became a legendary case. So an airline pilot and the horrible crash that happened on a Halloween. Anyway, he died in a plane crash, and his life insurance policy designated Jane Smith. Well, he had divorced Jane Smith, and guess who he married? Jane Smith. So the litigation was over which Jane Smith took under the life insurance policy. So you got to be super, super careful, and you know, going back to the date of everything. Anyway, just a little anecdote about those designations and how important they are.
Yeah, you know, and it emphasizes these third parties that we're dealing with. And like my case may be going back and convincing the legal counsel for this IRA sponsor, like, okay, this is why you need to pay it to this person or these people. You know, it's, you know.
Well, I know oftentimes Mary Beth and I find, because while we work with people while they're going through the divorce, a lot of people, they're exhausted by the divorce process. Even if they went through a better process such as mediation or collaboration, they're still exhausted. And they may say, you know what, I'm just going to kind of put this away for a little bit. And even if they did update their estate documents, Mary Beth and I often find that accounts haven't been retitled, beneficiary designations haven't been updated. And, again, there are rulings or, precedents from the courts. But again, if you take the time now, the money's going to where you want it to go, and you're not having, you're going to have to involve attorneys at some point. And so do you do it now while you're competent and say, this is what I want, versus, your beneficiaries or competing interests are now going to court. So again, that's a thing where I know oftentimes, Eric, that you do this, and most estate planning attorneys, hey, we've updated your documents. Either I can help you do this, or here's a checklist. But many people, it's very common, they have attorney fatigue after a divorce. Well, I'll just do it on my own. This way I'm not paying your hourly fee or things like that. But we all know you walk out of the door or hang up from the call and life happens, and it tends to fall to the bottom of the to-do list or priorities. So that's
Agreed.
again, go on.
Agreed, and which is why I insist that everybody have a financial advisor, because they are shot and they are not going to listen to me, all the directives in the world on all
Right.
the I leave them with literally a checklist, and
Of course.
they just won't do it. Again, I don't need to guide you through it. Well, that's why a good financial advisor will take it from there.
And
All
Nicole
right.
and I often say, they'll say, I'm so glad my work is over because the divorce was finalized, last week. And we say, oh no,
Just begun.
yeah, there's a lot that needs to still be done. So.
Yeah.
Okay, folks, we're going to move on to what might be our final question, actually. And that question I'm going to hand to Nicole Romito. The question is, how do I plan for my financial future when my ex keeps litigating? Litigation is expensive to start with, so how do I plan for this financially?
I can certainly start off, but would welcome for Mary Beth and Beth to chime in as well. I mean, it is a little bit of an unknown, so it's not going to be a finite cost that you can define up front or even in the middle of it and plan for. What I'll start with, and then Mary Beth, I'll tee it up to you, is you do want to kind of understand, this is where by having a financial planner on your divorce team, working with your attorney and you to, if you're litigating and you're powwowing about what possible settlement outcomes could be, you can start, the financial planner can help you start to say, if this is what you are getting, if this is the agreed upon outcome, or if you're litigating, this is the court puts upon to you, is a financial planner can help start taking those examples or the possibilities and saying, here's what it'll mean to you going forward. So even though I would say all of us on this call, if we had to prioritize the different ways to go through the divorce, generally speaking, one thing there's never always or never. There's usually different gradations in between, but generally speaking, we would say litigation would be the least palatable choice to go through divorce. Because as you asked as you noted in your question, it's very expensive and you're giving up control. But again, you can still have the various team members, whether it's a financial professional or a coach, to help you and your attorney still try to get you the best outcome possible. And that's where the financial advisor can help you and your attorney as they're negotiating or going in front of the court to help craft their defense or support of their argument of, here's why you need this amount of assets, or here's how we would like to see maintenance and child support structured. again, I understand there's guidelines and statutes, so trying to stay high level without getting down the rabbit hole. Beth or Mary Beth, you want to add on?
Well, I'm cheating a little bit because I happen to know the person.
Oh, okay.
And well, but it allows me to add a little more color for anyone who, so very often, as we all know, litigation is the only option when there is an imbalance of power, or if the person is going to continue domestic violence, which is not just physical abuse for those who don't know. It's emotional, sexual, physical, financial abuse. And the only way a person can continue to abuse a person is to do that financially, and using the court system is sometimes the best way to do that. So I think what is often done is somebody literally just keeps fighting to drain the other person of all their resources. So there are some areas of relief under the law as far as getting attorney's fees paid for by the spouse. Unfortunately, you know, when you're in the system, you're at the mercy of a judge.
Right.
And sometimes these judges are just not doing what the law says they're supposed to. So it becomes challenging. And I don't know from a financial advisor standpoint what you guys can tell people to do. Because there's, you know, other than, you know, I have literally had people just stop having an attorney just to kind of stop the bleeding and just know that the pain that could be, or the damage that could be done could not get any worse, right? So just take a litigation break, literally just stop and see if that kind of, the flames kind of lessen a little bit by that kind of break. There's no real good strategy on these situations.
Yeah, they're tough because again, they're motivated not by money, but by power and emotion.
Yeah.
And, you know, I did have a client where it was an excellently drafted MSA. But the other person felt that the monies that were being given to that spouse were really not deserving to go to the spouse. So, and as a result, would try and find even tiny loopholes in the MSA, and it did get expensive. So what we ended up doing is having to budget. And then, like you already indicated, Beth, at some point she just said to the spouse, we're not going to continue doing this. This just seems silly. But, and then finally though, that judge did actually, once the fees had to be paid by the spouse that was, initiating the motions, I think they stopped because the person had to absorb both attorney's fees.
Yep.
So
Yep.
that's usually, if you can get to, and fortunately there's a lot of pain inflicted before you can get to that point, which is hard. But usually when they start to realize that it's going to cost them for both of them potentially, that does get their attention anyway.
Yeah.
Okay, everybody. Thank you for all of your insight into this extremely complicated situation. But as it is almost 1 p.m., we're going to be wrapping up pretty shortly here. But before we do, we want to leave all of our guests here with a kernel of wisdom from each of our panelists. So if you wouldn't mind getting us started and share a kernel of wisdom with us, Mary Beth.
I guess, yeah, it's what I started saying a little bit ago, which was that it's really important to understand where you are currently. So pulling any documents that you can pull together, like whether it's an estate plan, if it's tax returns, so that when you do put together your team, that you're at least really aware of where you are currently, so that, people like Nicole and I and Beth and Eric can take you to where you want to get to going forward.
I'll piggyback on that. Knowledge is power in my arena. So just exactly what Mary Beth is saying. The more armed you are, I say if you're going to battle, you would not go to battle without ammunition. So literally there's rarely a piece of paper that's not valuable that, often you may think it doesn't matter. Well, it leads us to another path. So literally I have people come in. If you want to save a lot of attorney's fees, come in super organized, have it bound, have it indexed, somebody's got to do that. You certainly don't want to pay a lawyer or even a paralegal. Do that if you can. If you can't, have a friend help you. Again, use your support system to help you build that ammunition.
And I guess I would say, for someone who's, divorced and you did do some estate planning, with your spouse you're now divorced from, even if you don't feel comfortable going back to the same lawyer you used, what I would also encourage is sit down, an hour of my time isn't a lot. And, I could sit down with you for an hour or two and kind of just go through things for you and help you kind of, take notes on what you need to do and help you begin to prioritize what changes are there and to go through them. That's probably, and then you can decide, okay, thanks for that advice. I'm not ready to spend more money on this, but at least I've got like an action plan and a priority, and you can just keep that in your file at home and, pull it out when you're ready to, kind of begin to address things or figure out. And I can always kind of direct you, like, guess what? A financial advisor can really help you with that problem, or you can go and do this on your own and that'll take care of that, and maybe this, this is maybe a big surgery on your estate plan. So maybe you want to hold off on that till, you feel like you want to prioritize that. So.
And I think piggyback with our theme here is we understand you're exhausted, and you may just want to take a break from it all, if you will. But even if you decide not to make a choice, you're still making a decision, because for the state of Illinois, there's a lot of laws on the books that they said, okay, if people don't have the proper documents or titles in place, or you didn't update a beneficiary or things like that, there's still, the decision is going to be made, and it may not be how you thought it was going to or how you wanted to. So I agree with Eric. I know, at least for Mary Beth and I, we're always willing to talk to anyone. And if we're not the best fit, we certainly know a whole host of other financial professionals who may be the right fit. But talk to a professional, whether it's in the area of family law, estate law, taxes, financial planning, mental health. Friends and family are great, but even if your sister-in-law is a therapist or a CPA or things like that, oftentimes it's better to get someone kind of like at arm's length who doesn't have any background or any ties to you personally. And
who doesn't love you.
Yeah, there you go, exactly. So you may spend more money inadvertently. So get to the right people up front, get yourself set up for this next chapter. And then guess what? You have your new team on board, and then you can go and focus on what you want to in this next chapter of your life.
Great.
All right.
So I'm going to wrap up. So we want to thank everybody for their great questions and their participation today. We hope that you gained knowledge and hopefully some peace of mind, so that you feel better equipped to move forward on whatever process or path that you choose to take. I would like to offer, oh, here we go. We're putting up the contact information. So if any of you would like to contact us directly, please feel free to, take a snapshot of that slide, or you can also reach out to Nicole Young, our marketing manager, and she will make sure that we connect you with the professional with whom you want to talk. And then finally, I would like to just make you aware that Nicole and I are going to be having another webinar where we're focusing on the impact of divorce as a business owner. So if you have a spouse, or you are a spouse that owns your own business, or you're involved in a services firm such as a law practice or accounting services, that would be something that we would highly encourage you to join us for. It will be again September 29th at noon. So if you are on our Project Venus distribution list, you should be getting that, but please also feel free directly to reach out to Nicole Young. So thank you all. Enjoy this beautiful fall day, and thank you for joining us.